Thank you guys for joining us. Just give us a few moments to allow others to join. We'll get started right at 6:02. All right, thank you for joining us today. My name is Kalia Aparicio. I'm the programming chair for the NAHSE Houston chapter, and I am more than happy and proud to introduce Zenobia Bivens. She is a trial attorney and the member in charge of the Frost Towns Houston office. Her practice focuses on business litigation and all things related to the U.S. government contracts. Zenobia has won numerous jury verdicts and trial court decisions. She has served as a counsel in cases involving NAHSE, the Department of Housing and Urban Development, Health and Human Services, and the Department of Defense. She also has helped her clients implement compliance programs and advise clients being investigated by municipal, state, and federal government entities. Her cases have been featured in Forbes magazine, the New York Times, and the Houston Chronicle. And she has been recognized as a Texas Super Lawyers Rising Star, was named a top women lawyer in Texas Monthly, and named top Houston lawyer by Houstonian magazine multiple times. Zenobia frequently writes and speaks on the procedural issues that arise in parallel proceedings, which are cases involving both civil and criminal allegations. Zenobia, I'll hand it over to you. Thank you.
Thank you so much. I'm really honored to be here and to have Frost Brown Todd do this partnership with the NAHSE Houston chapter. This is the second of 3 panel presentations we're presenting to you. Tonight, I called on some of the people I trust in the firm on various topics. And unlike our previous panel, where we talked just about fraud, waste, and abuse and the laws surrounding that, tonight is about hot topics in the healthcare industry. And so each panelist has a standalone presentation for about 10 to 12 minutes on various issues. And I've called upon one of our extraordinary associates in the firm, Brittany Bradshaw, to guide us through tonight. And at the end, I'll talk to you about our next panel presentations that will involve, it'll be in person, and it will be general counsels from various healthcare systems in Houston. But without further ado, I want to introduce the moderator for tonight, Brittany Bradshaw. She's a managing associate in the Ann Arbor office of Frost Brown Todd. She specializes in representation of startup and emerging companies at all stages of growth, from formation and corporate governance matters through exits transactions. Her practice focuses on general corporate counseling, commercial contracts, venue capital financing, and mergers and acquisitions. Brittany represents clients across a broad spectrum of industries, including technology, automotive, mobility, consumer products, and manufacturing. So all the speakers are going to turn their cameras off except for the person who's going to be speaking, and I'm going to turn it over to Brittany. Thanks, Brittany.
Awesome. Thank you, Zenobia, and welcome everyone. Thank you for joining us this evening. This evening, you will hear from several dynamic and knowledgeable individuals on everything, different hot topics on venture capital that are touching healthcare. First, I would like to introduce you to Nicole. Nicole Tepe is an intellectual property lawyer at Frost Brown Todd in our Cincinnati, Ohio office, where she specializes in patent law. Her practice is concentrated in the area of biotechnology and includes both patent prosecution as well as opinion work. Prior to joining Frost Brown Todd, Nicole worked as a consultant at the University of Cincinnati Intellectual Property Office and as counsel to the Procter & Gamble Company. Nicole's going to be speaking with us on the first of 5 topics today, intellectual property basics for healthcare. Take it away, Nicole.
Thank you, Brittany. I appreciate the introduction. So as Brittany said, I'll be talking about intellectual property basics for healthcare professionals. And while I could talk about this for about 2 hours, I'm only allotted 10 to 12 minutes. So I'm going to sort of speed through the slides here and see what we can get through. So thank you for the first slide. So there's 4 basic types of intellectual property: patent, trade secret, trademark, and copyright. And these are governed by a mix of federal and state law. And we'll be talking about these, and I've made an attempt to highlight how this might interact with healthcare practice as we go throughout the slides. And it's fairly patent heavy because that's my practice area, but we'll get through all of them. So for those of you that like trivia, here's an interesting fact about patent and copyright laws. They actually find their basis in the US Constitution. So Article 1, Section 8, Clause 8 reads that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and their inventors. So this is, go back one there, Zenobia. So this is authors representing the copyright laws and then inventors, the patent laws, the exclusive right to their respective writings and discoveries. So this is the basis of patent and copyright protection, and it establishes a limited monopoly for both copyright and patents. Next slide. Thank you. So first, what is a patent? It's a government-granted monopoly on an invention of a limited term. It's a 20-year term from the filing date. It used to be 14 years from grant, but the US changed to harmonize with other countries. Patents are regional. This is something that I hear from people quite often. So for example, a US patent is only enforceable in the US, and a Canadian patent is only enforceable in Canada, et cetera, et cetera. And there is no such thing as a global patent. You may hear someone refer to this, and they're probably referring to a PCT application, which is a patent application that can be filed to hold your foreign rights, but there is no actual global patent that can be issued. Another thing that I see with individuals that they get a little bit confused about is they might come across a patent or a patent application and say, oh, we can't do X, Y, and Z because there's a patent on this, but what they're doing is they're looking at the patent as a whole, and they're looking through all of the information in the patent. What's really important is at the end of the patent are the claims, and that's what defines the picket fence around your invention, or what actually you can enforce against others. So that's an interpretation issue that may come up for you. The underlying rationale for patents is that it's a quid pro quo. So in exchange for this limited monopoly, the inventor has to teach the public how to make and use the invention. And then after the end of the patent term, this information goes into the public domain. So a very concrete example of this that you're probably familiar with is the expiration of patents on drugs, after which a generic company might step in and make the generic equivalent. So that's an example of a patent, which then the information afterwards the information goes into the public domain and the public benefits. So that is the rationale for that. Next slide. Thanks. Okay, thanks. So how might patents affect your day-to-day activities? So as healthcare executives or individuals, it depends. Does your organization have an active research component? Are they collaborating and innovating? Are employees expected to research and publish? And if so, you may want to consider how IP is being handled. How is it being captured, and how is it being filed on? How are you licensing IP out? How are you licensing it in? Do you have an IP policy that applies to your employees, and how are employees being compensated for their IP efforts? Another important consideration, and perhaps the most important, is who owns the IP that arises out of your employee efforts. So if you're an organization with a very active innovation contingent, this may require deeper consideration of the issues and a more focused IP policy. Next slide. So we'll just kind of breeze through this real quick. So this slide is to let you know that there's 2 main sources of funding that you might encounter. One is federal funding, for example, NIH grants with respect to patents, and the other one is might be private funding, such as a sponsored research agreement. If you have federal funding, then that triggers reporting obligations, which we never like to have obligations if we can help it. Whereas if you have the opportunity to get private grant money, you can spell out the responsibilities and the benefits of that contract. Okay, so next slide. So why would you bother filing patents? Well, as a healthcare institution, this may create value, both monetarily, but also reputationally. Granted patents and pending applications can be licensed, and quite often a pending patent application has more value because the licensee can control the outcome of the filing. And then it's also important to know that patent rights can be granted in a myriad of different ways. You can slice and dice a patent or a patent application and the rights contained therein hundreds of different ways at least. So for example, the slide mentions territorially for like certain markets, field of use, for example, certain patient populations, certain indications. And then of course, as I'm sure you're aware, these could be non-exclusive or exclusive licenses. So this is just to highlight all the different ways that you might want to consider licensing out IP if you have that to license. Okay, next slide. Thank you. This is a watch out. So with new hires, you want to make sure that you're determining IP ownership up front. By law, under the federal patent laws, the inventors are the default owners of a patent filing. So it requires an assignment to transfer that right from the inventor to the employer. So employment agreements should include an obligation to assign. And you always want to follow this up with an actual assignment. If you have a former employee who is also a disgruntled employee, it may be very difficult to get an assignment after the fact. So when you, as soon as possible, you want to make sure that you get assignments in place for any inventions. I also wanted to highlight here that incorrect assignment documents can jeopardize your foreign rights. And then also improper naming of inventors can actually invalidate a patent in the US. So these are two issues where you want to be very careful. And also inventorship is a legal definition that's different from authorship. So that's something that you may have to navigate if you're considering your IP policies. Next slide. Thank you. So infringements, so patents are a double-edged sword. On the more positive side, you might have a patent right that you can license out and have an income stream from that. But on the flip side, someone might assert their patent against you, and that would show up in the form of a cease and desist letter. So this slide is just here to warn you that such a thing could happen, and that you want to make sure to get yourself out of that situation as quickly as possible, and stay away from any sort of patent litigation whatsoever if you can help it. Next slide. Thank you. We sort of already mentioned most of these things, but some of the patent problems that can come up, statutory bars, if you have inventors that are getting ready to publish or present or put something into the public domain, you want to be very careful about that and make sure you're filing ahead of that public disclosure. Assignments are very important and can wreck your portfolio if you're not careful, naming of inventors, and then also incorrect listing of government grants. You want to make sure to get all those things right. So while I could talk about this for hours, the next slide, well, that's all I have here for you for patents. And then we'll move into trade secret just briefly here. So trade secret is essentially the opposite of patents. Unlike patents where you publicly disclose your patent application, how to make and use an invention in exchange for that limited monopoly, a trade secret has to be kept secret. So once it gets out in the public domain, it is no longer a trade secret. So you need to be, it's something that needs to be vigilantly protected. What it doesn't protect from is independent development. So if somebody, so for example, if a competitor, Coca-Cola, were to make their own version of Coca-Cola, which actually contains the same thing, they could compete against Coca-Cola and they would have no recourse. So examples of healthcare trade secrets include digital products that might include algorithms or things of that nature, things that you can protect and keep secret. It doesn't need to be disclosed to be used. Okay, next slide. Okay, so trademarks. Trademarks are a completely different animal from both trademarks and patents. I'm sorry, from both trade secrets and patents. And they serve an entirely different purpose. So trademarks are really source identifiers. They're rooted in consumer protection and they tell the public where a product is coming from. There's a whole wide range of different things that can be trademarked, and here are some examples here. Nike words, for example, Nike or Delta, those are two examples of trademarks. Designs can be trademarked. So if you imagine the Nike swoosh, that's an example of a trademark. The tagline, just do it, that's another Nike example of a trademark. And then there's also very many non-traditional trademarks. So a product shape, for example, the Coca-Cola bottle is an example of a shape that is a trademark. Color, such as the Tiffany blue or pink for insulation, and then sounds can be trademarked as well. So an example of a trademark sound might be the NBC chimes or the Netflix opening sound that plays. And not listed here that I forgot to add onto the slide is scents can actually be trademarked as well. There's at least one instance of a scent being trademarked, and that's in conjunction with a or in connection with a thread, sewing thread that had a scent associated with it. So that can be protected as well. Next slide, please. These are some considerations. I don't know if you'll be in the position of selecting a mark or not, but if you are, there are a few considerations you'll want to consider. You want to select a very strong mark, and you want to be sure that you're doing clearance searching and that you're not accidentally creating a mark that's very close to, confusingly similar to somebody else's mark. In this graphic here, it shows the spectrum of trademarks and how strong they are. So you can see at the least protectable and not protectable at all really is a generic mark, such as you can't trademark the word apple to protect apples. And then the strongest mark would be a fanciful mark or a made up word such as Xerox or Kodak. And then in between we have examples of other descriptive, suggestive, or arbitrary marks that can be protected. You might have noticed that some marks have the word or the initials TM beside it, and some have a circle R designation. The TM means that it's considered a trademark by the trademark owner, but it hasn't been registered with the Patent and Trademark Office, whereas the circle R designation means it has been registered with the Patent and Trademark Office. And also just to make sure you know that the registration of a trademark requires actual use or intent to use. So you can't just bank a trademark with the Patent and Trademark Office. Next slide. Okay. This is my last slide, so you're almost free of learning about IP. So this is the last type of IP to talk about today, copyright. So copyright protects original works of authorship fixed in a tangible medium of expression. What's interesting about copyright is that it happens automatically. So if you were to be sitting at your desk and you write a poem on a piece of paper at your desk, that's automatically copyright and you own the copyright to that. Copyright often becomes completely intertwined with the work product of the business. So for example, if you hire somebody to write an article, or someone contributes an article that becomes posted on your website, you don't necessarily own the copyright to that, and you probably don't. So you want to be very mindful of who owns the copyright in your important media, and you want to make sure to use those assignments that we talked about earlier with respect to patents. You want to also use that with your copyrighted materials, and you want to gather up ownership of that if you can. Some of the healthcare-centric copyright examples might be questionnaires or checklists, algorithms, and of course, scientific papers. These are examples of copyrights that you might encounter, and many of these can be monetized for your business. And that is my entire presentation about patents and intellectual property.
Thank you, Nicole. I do see we have one question currently in the chat. If anyone else has any questions for Nicole, please feel free to type them in. The first question we have here, Nicole, are there any cases where the length of a drug patent is reduced for the public good? The COVID-19 vaccine comes to mind, but curious if there are other examples.
Yes, that's a great question. That term is not fixed in stone, the 20 years. There can be compulsory licenses for the public good, which doesn't necessarily shorten the term of the patent, but what it does do is it requires the patent owner to grant licenses to that technology. So that's, and I can't recall if they did that during COVID or not. So, and I really should know that. But yeah, so that's a great question, and that term can sort of fluctuate for different reasons. And that's not really a term adjustment, but it is a modification of that right for sure.
Thank you, Nicole. Again, if there's further questions for Nicole that you have now or after, feel free to drop them in the chat, and if we have time to circle back to them at the end, we certainly will. Moving to our second topic this evening. Oh, sorry. We actually have a door prize coming up first.
So today we elected the first door prize. It's gonna be a $50 Amazon card for the first person that joined, which was Miss Yvette Muro. Just make sure that you check your email for further details. Thank you.
Thanks, Kalia. Our second topic this evening will be venture capital in healthcare, from venture capital to better outcomes. I will actually be talking to you this evening about venture capital. So just to kind of get started and sort of level set, I want to start with a few companies that you all may have heard of before we talk about what venture capital is. So first, a company called Dexcom, founded in 1999, designs and commercializes continuous glucose monitoring systems for diabetics. That company actually has received $71 million of venture capital financing in its early stages. Again, that company was started in 1999. One that is somewhat more recent, 23andMe, founded in 2006, of course, is the consumer genetics and research company, which helps people access and understand and sort of benefit from the human genome. That company has received over $873 million in venture capital financing. And then one that we are all probably overly familiar with, especially if you watch any commercials or advertisements over the last year and a half, would be Peloton. Peloton, similarly related to the health arena, is a company that was started in 2012. Of course, as we all know, they operate an interactive fitness platform and design connected fitness products such as the bike and tread. Again, founded in 2012, already has received over $1 billion in venture capital funding. So just wanted to highlight those few companies, one, because they all kind of touch on the health arena in different ways. And secondly, to show you how over time, the amount of money that has been invested by venture capitalists has just been skyrocketing. So again, what is venture capital? I'm sure many of you may have heard this term in passing. Next slide, Zenobia, please. Thank you. Venture capital essentially is a form of financing where money is invested into a company from investors or a group of investors in exchange for those investors receiving stock or equity in a company. Essentially, the investors become part owners in the company at its early stages. As many of you can imagine, this is a pretty risky situation for investors to put themselves in. These companies are often new and novel ideas that no one is really sure if they're going to work in the market or not. No one could have predicted that people would not be able to go to the gym last year and that Peloton was going to take off in the way that it did. But again, essentially the point of venture capital is for investors to really get in early on at the early stages of a company when the value is still relatively low, in the hopes that over time, the value of the company will grow. Next slide, please. So often you will see venture capitalists sort of group themselves into what we call a venture capital fund. So a venture capital fund itself is often a group of individuals, investors that have pulled together money to invest and manage together in different startups, different high growth companies. So in addition to writing checks though, venture capital funds are extremely advantageous to startup companies for a few different reasons. One, they play an extremely active role in shaping the company's success going forward. They often provide the startup, for example, with business expertise, connections, just tips and guiding them through the industry to help grow. They often will even participate directly in the governance of the company by sitting on the board or some other advisory role where they're really kind of being able to affect the day-to-day decisions of the company. And this is typically a very hands-on long-term relationship because again, if now that the investors are part owner of the company, if the company does well and continues to grow, the investor gets a better return on their investment. But as I indicated, of course, these investments are super risky. So what's in it for the venture capitalist? What's in it for the investor? Next slide, please. Well, $1 billion market opportunity, simply. Venture capitalists and especially venture capital funds are often looking for what they call a unicorn, or $1 billion plus opportunity. So that means a company in the market that has the ability to generate hundreds of millions in sales in a relatively short amount of time. And also they're looking for companies that can really capitalize on their ideas or their product and really make an impact in 5 to 10 years before that company exits and goes public. One example, although not in the medical space, but very near and familiar to us all, would be Uber. Uber started out as a startup high growth company that received venture capital investment. As a venture capitalist, if you invested only $5,000 in Uber at its early stages, you would have made $25 million when that company went public, which is a 5,000x cash on cash return on the investment. So again, as you see, these investments are more risky, but the payoff is extremely high. Next slide, please. And this slide here will just show you, how 5 to 10 years seems like an incredibly short amount of time to take a company from something you invested $5,000 into versus now something that's worth $25 million for that same amount of equity. So here we've kind of laid out what that really looks like from the healthcare perspective. If someone was bringing a sort of biotech product or a medical device to market and seeking venture capital funding, when would they seek that funding, and what does that look like? So you'll see here kind of the general life cycle of a company. Again, it's usually 5 to 10 years before they exit if they are engaged in venture capital. Early on, very early on, when they're not sure if the product's even feasible, that may be too early for venture capital. They're probably still then receiving grants, maybe even checks from some friends and family to fund their research and development. But as they move down the line into preclinical or clinical trials, even commercializing the product, and certainly into expansion, that's really when venture capitalists start to get interested. They see that there's a product that looks like it's feasible in the market and that it can grow and really have that return or potential for high return on investment. Next slide. And the United States is the global leader in venture capital. In fact, in 2020, the US set new venture capital records that have exceeded tremendously what the US has done in the past. So for example, in 2020, there was over $156 billion of VC funding still kind of floating around and being invested into companies in the country. There was some concern early on with the pandemic and how that may affect just the economy and investments, but particularly, as you can see here, continuing through the first quarter in 2021, in the health and wellness and biotech space, especially, we saw those numbers grow over what they were previously. But the first quarter, 2021, over $1.5 billion in biotech and $353 million in the US invested into health and wellness early stage companies. And also, one thing I wanted to highlight too, there was over 13,000 different deals or transactions that happened in 2020 between venture capitalists and their companies. So you can see that venture capitalists are starting to really get interested in technology that's sort of shaping the way that the country is moving forward. Again, here this just shows that 2020 was a record year again, especially when it comes to biotech and pharma activity. Over $27 billion in 2020 was invested into those industries, startups, which was 10 billion more than just the prior year in 2019, and 5 times more than where we were in 2010. So it really kind of makes you wonder where some of this increase is coming from, particularly last year. Obviously, with everything that was going on, there's been a lot of developments in the medical space and medical technology, particularly, which is what probably is contributing to the huge increase in numbers here. So to highlight, we've kind of talked a bit about the venture capital funds and venture capitalists, but just to highlight a bit again, on the types of companies they're really looking to invest in. Venture capitalists invest in high growth startups, companies that have developed a product or a service that can really be a massive disruptor in the market. Again, thinking of companies like we have a traditional, at least we did have a very kind of traditional gym model that Peloton has now come into the market and completely disrupted. And you're now seeing other companies doing very similar things, similar to how we had, a very traditional kind of taxi cab sort of scope in this country, and Uber and now Lyft and others have changed that. And we've seen similar things with hotels and Airbnbs. And now similarly, again, in the medical space, we're just seeing a lot more research and development just really being focused on certain areas in the medical field. Next slide. And those areas really kind of can be broken down into 4 main components when we're talking about sort of healthcare innovation. One being, of course, your biotech. Then we've got your sort of digital health. That'll be any of your apps, your trackers. If your Fitbit or your Peloton kind of tracking, medical devices that are wearable, diagnostic devices. We mentioned earlier Dexcom, the kind of glucose testing device. Those 4 areas have just been exploding recently with venture capital funding. And one area of the company particularly that has been huge in this area is sort of the Northeast region. So we have found, especially recently, that there are a lot of bio and pharma and kind of software related companies that touch in the medical space coming out of that Northeast region, particularly New York City and Boston. Those 2 major metropolitan areas alone have invested over $33 billion in just bio, pharma, and healthcare related software. And that was just in last year, 2020. So kind of where are we going next from here? Really, again, just looking at the trends that we've seen over the past few years and how things continue to grow, it's looking as though that medical device companies, particularly, and biotech companies and pharma companies are going to continue to see record-setting numbers in venture capital investments. Here, we just wanted to highlight for you 3 companies that are kind of up and coming in the space. Contessa, EQRX, and Leiden Labs. All 3 are very relatively new companies that were formed right at the onset or even during the pandemic. Again, you would think, man, it's a crazy time to start a company, but as you can see, again, venture capitalists are extremely invested and interested in what's coming out of the medical space. So we are still seeing Contessa, for example, $250 million raised. That company went public in 4 months from the time it was started to the time it went public, which is a crazy short amount of time. And we are just kind of seeing those things continue to ramp up as we continue to move down this path. It'll be interesting to see sort of trends and how those continue to hold up as we move forward. But again, we're just seeing a huge amount of interest in this space, and a lot of it we believe has come from the major shakeup that we had in our healthcare industry last year. So again, we are seeing venture capital really kind of having a hand and a foot in sort of pushing the healthcare companies really to that next level. If there are any questions that you have for me on venture capital, please feel free to again drop those in the Q&A as we continue, and we will collect them at the end of each topic and circle back to them at the end. I believe we have another door prize, so I will turn it over to Clea.
Thank you so much, Brittany. So the next prize that we have is a $100 State 48 gift card. And the lucky winner is, don't all get excited at once, it's going to be Miss Alicia Merchant. Congratulations.
Thank you. So next, we're going to hear from Eric Cook. Eric is a privacy and data security attorney in the Cincinnati office of Frost Brown Todd. He's a certified information privacy professional with the International Association of Privacy Professionals. He provides guidance and counsel on healthcare, mobility, logistics, and a variety of technology businesses, with a particular expertise in the Children Online Privacy Protection Act, the Telephone Consumer Protection Act, state biometric policy laws, and various other state privacy regimes. Eric's going to be presenting today on data privacy and security issues for healthcare professionals. Thanks, Eric.
Thank you, Brittany. Thanks for the introduction. Great to be here this evening. I'm going to start by giving a brief introduction to what I'll be speaking about, which will be data privacy and security issues. In many ways, the data privacy and security issues I'll be discussing, although general, all of them apply to healthcare professionals because a lot of these issues are coming across in this particular area. Feel free to advance the slides. And I think we can jump to 3. Thank you. Back to, thank you. I think the biggest thing that I want everybody to focus on is making sure they're asking the right questions. Privacy and data security laws are changing pretty much daily. At this point in time, we've obviously got 3 state laws that are in effect, each one to some extent, going into effect, each one to some extent kind of exempting healthcare information to some extent, but that's kind of what I'm going to be pushing you all to be thinking about. And so I want you to be asking yourself, what questions should I as a healthcare professional be asking? And you should be asking the same questions everybody's asking, which is what types of data does my business collect and how am I using that data? What type of policies and procedures do we have in place to protect that data? And what are we telling the public about that data? When I say what types of data, most of you will be thinking, well, I'm a healthcare professional, I'm collecting PHI, I'm collecting protected health information. However, even though HIPAA is going to apply to that data, you might need to be considering what other personally identifiable information you're collecting that might not be HIPAA data, particularly on public-facing websites, and trying to figure out what your policies and procedures are with regard to that particular data. Are you treating that just like HIPAA data? Or are you treating that differently? Are you discarding it or are you using it for some other purpose? Just because it's a covered entity or a business associate does not mean they can collect the data that is not necessarily HIPAA covered data and use it just in any particular form or fashion. Feel free to advance the slide. The biggest thing I want us to also focus on is the difference between privacy and data security. And in many ways, they are definitely different, but very, very much connected. So once again, you need to be asking yourself, what personal data am I collecting on a public-facing website? And that's particularly when I'm talking about that. I'm talking about users and patients, people that are coming to a website to collect or get some additional information or trying to get some type of medical service. In addition to what personal information might you be collecting about employees. Once again, that's focusing on the data privacy aspect of that. The other aspect is how am I actually protecting this data? Who actually has access to this? And that aspect is not just limited to users or employees. It's limited to, it can also be expanded to trade secrets, IP, as Nicole discussed, or just basic confidential information. How am I protecting that information in addition to how I might be collecting that other information specific to users and patients? Many of the privacy laws are obviously focusing on one or the other a lot of times, and HIPAA, obviously the HIPAA privacy rule, and then later the HIPAA security rule. But now what you're finding is many state laws are kind of hitting both. There's a particular focus on privacy, but there's always some later focus on the particular security requirements and how people are protecting that data. I mentioned this particular Forbes article where the test of COVID vaccination websites, there was kind of a study done where they looked at a ton of COVID vaccination sites and realized a ton of cookies were being dropped on people and users who were going to the websites to obtain some type of vaccination information. Question you should be asking yourself is, do we need to do that? Do we need to be following users around on other sites to determine what else they're doing? The other issue you have to worry about is, well, if I have some type of service provider who is actually dropping that cookie on my website, they're the one managing my website, and then they have a breach. Now they have, whoever has hacked them has access to whatever cookie has been followed around, whether that's my research to, go on my next trip, or my research to do something medical that has nothing to do with the covered entity and therefore not protected under HIPAA. So as a result, that you have to realize how intertwined privacy and security are. Privacy in particular is always going to focus on transparency, notice, and whether or not you should be collecting in the first place. That question about should I be dropping a cookie? Security obviously is going to be focusing on the access control and the ability to keep individuals out who actually has access, service providers, or who subsequently can get access. You can advance the slide. I wanted to begin by, separating. Obviously, there is HIPAA, but there's no general federal privacy law that's applying to everyone. The Federal Trade Commission, however, does enforce privacy and security through its Section 5 powers. So as a result, they are basically going after companies who are using unfair and deceptive practices. And the moral of the story is what you say on your privacy notice, what you say in your policy, whether it be the notice of privacy practices to your patients or to just general users who are accessing your website for information, you have to do. That includes what you tell them you're going to do to protect their information. This health breach notification rule is something people should be aware of that the FTC enforces, and quite frankly is likely to get some more activity. The health breach notification rule does not take power away from Department of Health and Human Services or Office of Civil Rights. It is basically focusing on that bit of healthcare information that is not protected because of it being used by a covered entity or business associate. So think mobile applications that are collecting healthcare. There's a particular case where I think a mobile application was allowing users to actually, women in particular, to basically monitor fertility. That information was not protected. That information technically is obviously not under a covered entity or a business associate. It then came under this rule when there was a breach of this information by an employee. You can advance to the next slide. Privacy and data security rules and laws that should definitely be on your radar. I'm assuming or hoping at this point you've heard about the California Consumer Privacy Act, the Virginia Consumer Data Protection Act, or Colorado's Privacy Act. CCPA, California Consumer Privacy Act, is already in force, where people are starting to get letters with regard to non-compliance, but that was subsequently amended by the CPRA. These other two laws, Virginia and Colorado, will be going into effect in 2023, as will that amended California Consumer Privacy Act. You need to very well know that in every single one of these laws, there is an exemption for HIPAA covered information. The issue that's going to come up for many of you guys is whether or not it's still going to be protected and you only have to comply with HIPAA. HIPAA does not prevent stronger laws, but as a result of kind of complication, many of these states did not intend to try to make this a more onerous process. However, the big thing is what happens in some of this data that people are just throwing into the HIPAA bucket. You might just assume it's PHI that you're collecting or be treated as such, but it might not be. And as a result, come under the gamut of one of these particular laws. And then finally, what I think is important for everybody to pay attention to too is each one of these laws requires a data protection impact assessment. Healthcare, I think you guys are the closest to someone who's probably doing risk assessments or some type of assessment. These particular data impact assessments will require you to kind of look at how you're collecting, using, and storing information. And you're basically going to have to keep a record of that can be used and subsequently looked at in the event there's a data breach. We can advance the slide. Briefly on these are ones you need to pay attention to. Massachusetts data security regulation applies to any business that's collecting information of Massachusetts residents. So this particular law doesn't actually matter in the sense that it only applies to Massachusetts businesses. You can be in Houston, you can be in Texas, you can be in California, and if you're collecting information for Massachusetts residents, you have to have a written information security program. Illinois' Biometric Information Privacy Act, BIPA, you hear a lot about with regard to employees and other individuals suing regarding this. Facebook was a recent example, collecting facial prints of people using Facebook and kind of creating this massive database. And then finally, the Telephone Consumer Protection Act, which I see a lot of. There are exemptions for HIPAA covered entities or healthcare professionals in that sense. However, there's a I think there's about 6 particular parameters that you have to meet when you're sending text messages to a patient or user. And there's different ones depending on whether it's an informational message, just telling them about appointments, what's going on, when they need to return, versus the minute you turn that into a marketing message, any type of purchase. And just because you add telemarketing to an informational thing does not make it informational. It'll make it telemarketing, and you're subject to a massive class action and fines if you are found at fault. Could advance to the next slide. Everybody probably has heard about GDPR applying to particularly the citizens of the European Union. Everybody needs to be aware of data breach notification laws, which are not very complicated, but every state has one in the US at this point. They're very similar, but all of them might have some type of intricacy that's just a little different with what would require you to notify an individual. You know, under HIPAA, you're clearly notifying one place, but with the data breach notification law, you might have a subsequent obligation as well to notify the state Attorney General's office. You might even have to be required to put something in the news media, depending on how many people are affected. We have recently, well, not recently, Ohio had one, I guess a year ago. Connecticut just passed one where they are basically kind of doing the argument is like the carrot and stick. Instead of penalizing people, they're actually giving people an affirmative defense in the event a business has actually implemented reasonable security measures. So if you're following NIST, if you're following some of these guidelines, that's a way for you to basically argue, if you are sued, that there's an affirmative defense that you've been doing things. And then finally, I just briefly throw out there, this one's near and dear to my heart, but I'm gonna keep it short on this, is algorithmic bias. I don't think there's a law quite yet that has hit this, but you're seeing a lot of this in, you know, Netflix movies and all these things going on. And I think will particularly be determinative for healthcare professionals is whether or not the data that is being used and then subsequently used to create these algorithms are having a disparate impact or an impact on different individuals differently, specifically, obviously, populations of color, the type of care we might be getting. Once again, I don't think there's a direct law. I think you have to argue about this in a roundabout way, but there's been a lot of legislation coming forward about how we'll implement that. I don't think that'll be the next kind of big thing. Can advance to the next slide. Data privacy basics, kind of hit this earlier. You always want to have a privacy policy, terms of service, cookie policy for your websites that might be independent of your notice of privacy practices. You want to make sure you're reviewing your agreements with third-party contractors and service providers to make sure they're consistent with those external policies. Can't be telling everybody I'm securing the information, but you're not requiring it of your service providers. Can switch to the next slide. And then consistent with that, these internal policies for data security. You know, I make the old motorcycle joke about there are only two types of riders, ones that have been down and ones that are going down. At this point, a security incident is inevitable. You want to make sure you have an incident response plan, a written information security program, or information security program that's separate. I would recommend of all at least have this incident response program. And I imagine in the healthcare field, we always have to have some type of programs, but these policies are specific to how you want to respond. Next slide. And then finally, the big one that we're hearing, I stayed away from until this part, is because everything that you're doing prior to this, whether it be the privacy policies, asking the questions of what data I'm collecting, where is it at, how am I securing it, will all put you in a better position in the event, and likely in healthcare, that a ransomware attack happens. We're seeing news obviously left and right. There's executive orders that have been passed by Biden at this point in time, or issued by Biden, and there's subsequent legislation coming out about how we're going to have to respond. The biggest thing you're going to see in the news regularly, day in, day out, is that bad actors are infiltrating the healthcare system and other places through the supply chain. You need to make sure you have a meaningful program in place to audit, review, and assess your service providers and contractors. I'll say that again, something in place to review and assess your service providers and contractors is the place most people are getting into besides employees. You need to check and make sure you have cyber insurance in place, and that the policies and procedures you do have in place for employees and just the healthcare professional in general match that cyber insurance policy. You don't want to be in a position where your cyber insurance policy requires something that you're not doing, and now there's no coverage. I think I might be at the end. Tried to blaze through that last part. Okay. Key takeaways: inventory the data for your users and employees. Have policies and procedures in place, obviously, for the vendors and service providers. and it's inevitable that you're likely to have an incident. Breach is what it becomes once it's reportable. But you need to know how your business is going to respond, and how you guys are going to basically be operational, given that, you know, you're saving lives. Thank you for your time.
Thank you, Eric. I saw we had a couple of questions come in, one on IP and then one on venture capital. So Eric, you're up first. There are several security certifications that companies can use to show that they are protecting patient data. Is there a certification that is top in class for companies to pursue? For example, I believe it's called a high trust certification.
You might have caught me on that one. I don't know if I would say there's a particular one that's top. The certifications definitely help. I think the certifications in many ways just allow you to get an outside audit. And that's something I didn't talk as much about, but you do want somebody other than your own security professionals reviewing your security to basically pull together those lapses. And any of them usually will be able to pull that out if they're doing what they're supposed to do. But I think high trust is probably a good one.
Awesome. Thanks, Eric. The second question was, are there any certifications students can pursue to increase their knowledge and skills in venture capital? Yes, there is. So the University of California, Berkeley actually puts on a program twice a year that is open to the public called VC, as in Venture Capital University. The program's offered beginning in September and beginning in February each year. They have begun soliciting applications for their September 2021 cohort as of 3 weeks ago. So there is still time to apply for this cohort, but then again, they will open up another one towards the very end of the year that will start in February as well. If my memory serves me correct, I believe we have a door prize up next.
That is correct. Thank you so much for answering those questions. Our next door prize is a $100 Houstonia Spa gift card, and this one goes out to Miss Tassa Woods. Thank you so much.
And these are some great prizes this evening. Next, we are going to hear from Zenobia on the Federal Open Notes rule.
Hey, so I've spoken about this topic several times over the past several months, I think beginning in February, when I think a lot of hospital systems realized this was actually happening. So the Federal Open Notes rule is this idea that's been percolating since the 1970s that patients should have access to the notes that their healthcare providers are writing about them, that we should, as patients, have access to lab results. And the term that's used for this is interoperability, seamless exchange of information. And this started back in the 1970s because, you know, there's research done that said that if, and I'll talk a little bit more about it in a second, that if patients know more about why they're receiving certain treatments, they will follow those regimes, right? If patients can see their lab results, they will be like, okay, really, I'm sick, and then they'll follow the rules. So follow whatever guidance they receive from their physician. So we have this idea that you should not be, the federal government has now said you should not be blocking patients' access to their notes, right? So what is information blocking? It's any practice that is likely to interfere with, prevent, or materially discourage access of electronic healthcare information. And Eric is a great segue or a great preview to this, because as you have all of this information being given to patients, it has to be on a secure exchange, right? Like a MyChart or whatever you decide to use, Epic, whatever your hospital system or facility uses. You have all this information that now is required to be put basically what I call the iCloud of healthcare information. You have to make sure that it's secure. And so all the things that Eric was talking about previously are completely accurate in terms of going forward, and even more important. So I've heard a lot of people, particularly physicians, you know, grumbling about this because, you know, if you write something about a patient in the past and you didn't want them to see it, you know, you did your short notes, right? You didn't have to care about the patient actually seeing what you wrote. Now you have to, you're writing it, you need to write it in a way that the patient can digest it and understand it, and that you're not offensive, all these different things, right? And so we hear a lot of complaints from healthcare providers that they don't want to do this. But it's really important. And why? Because we have all this rhetoric going on right now about, we want patients to take ownership of their care. We want patients to follow through, let them be the owners of what they're doing. And then we have insurance plans are designed to help patients take ownership, choose who your provider is going to be. We have telehealth now. You can do it when you want, where you want. All this patient-centered care rhetoric. We have regulatory changes, right? This year, or actually in 2020, I'm losing track of my years. We just recently saw the changes to the anti-kickback statute and to the Stark rules, or the Stark law, that really allow you to get these safe harbors or protections if you're doing something to help patients take control of their health care. And so we're saying all that constantly, but are we really doing it? We need to do it, and here is why. There's research that shows that when you give patients access to their notes, the notes that the doctors are writing about them, to their lab results, they'll read the notes, right? I recently read my notes. I read my lab results from my annual physical before my doctor even wrote up about it. And I was able to Google about what the results meant. And so, I found out it was okay. But that kind of thing is, patients want to do it, right? And it makes sense, since we're living in a social media world where you want things like sort of right now, and you're used to constant disclosure. Patients will read them. They'll continue to access the notes. And it influences, and this is important for healthcare executives, their access to the notes influenced who they chose to be the provider. So the better the access, the more likely they were to choose the provider going forward. So this is not only something for patients' benefits, this change on the federal regulations that just happened. It's also important as a business, as part of your business decisions, because patients will choose you based on how much access you provide them. And there's a bunch of other benefits that are listed here. We'll share this PowerPoint presentation with you afterwards that you can read through if you're ever in a conversation with the provider and meetings about why this is important. There's real tangible benefit to this. Another study of 220 patients, before they wanted to read about it to understand their diagnosis, afterwards they still wanted to read about it, right? After having access to their notes. Another reason why, more research, patients are more engaged with their care. They understand the next steps for their care. They understand how to be safe, and more effective communication, right? Which leads me to another why. Malpractice and limitation of liability. Early on when I was speaking about this, there were rumblings about, lawyers will sue us more because they'll have basically everything they need to say that the doctor messed up. But at the same time, looking at it a different way, the patient also had access to exactly what the doctor had access to, and the ability to ask questions about that, right? And so what we've seen so far in the studies is that it hasn't led to more malpractice or more malpractice or litigation at all. And so this could actually help prevent malpractice suits if you're encouraging your patients to access this information as it comes to them. So stepping back, now we talked about the why, let's talk about how this came about again. This was the genesis back in the 1970s. There was a lot of patient advocate research done, but it wasn't until 2009 that you saw the genesis of the electronic health record, right, EHR. And there was a lot of encouragement by there was laws put in place by the government in 2009. It was actually a rider to the great I guess recession of 2008, right? When that happened and all the legislation went in to rescue our financial institutions, they did the electronic healthcare records at the same time. It was one of those riders that went through. And private healthcare was starting, insurers were trying to also make people go to health to electronic records, right? There was all these incentives. But fast forward and you have these healthcare records, and like there's fallout because people are not fully accessing their healthcare records. It's not this watershed moment that all the patient advocates in Congress wanted. So they went to an organization called ONC, and they asked ONC to help figure out regulations to help patients access their information and prevent healthcare providers from blocking them from accessing that information. So they wanted just some more step-by-step guidance. Unfortunately, it wasn't until 2016 that we had an act that actually put that into place. And it wasn't until 2020, the spring of 2020, that we actually saw these regulations come about. Well, in the middle of 2020, many people in the healthcare industry were busy with something else. And so the government said, we will not implement this until April 2021 and require you to allow your patients to have full access to their healthcare notes. So another important thing, so we know the why, you know, it's sort of the history of how it came about. This has been a long time coming. So who are the actors? And this is why you'll understand why it's important in a minute. There's the healthcare providers, but there are also the people who are dealing with the actual EHR, the healthcare records, and the electronic healthcare information, right? Two buckets. And this is why it's important under the open notes rule. If you are dealing with the tech side of things, it's you knew or you should have known, right? You violate this law if you knew or should have known that what you're doing was violating the information blocking laws, right? That you knew or should have known that you were blocking patients' access to information. And that's a pretty low standard. And so if you're dealing with, if you're like a company that's dealing with this, you know, this iCloud of healthcare information, you really have to pay attention to this change, because you could be held liable pretty quickly, pretty easily. The other bucket of actors are healthcare providers, probably more in your realm of day-to-day practice. The healthcare providers, the standard is really high for them in terms of violating the law. They have to basically know that they're violating the law. But the key part to this is, was the practice unreasonable, and was it likely to interfere? Did they know that it was unreasonable or likely to interfere? And so when we talk to our healthcare providers, we tell them it's something like you basically dialing it in when it comes to doing your notes, right? So before doctors taking their notes and they're writing, you know, candidly their thoughts, because only they get to see them. Afterwards, like I said earlier, it's open to everybody. And so the issue comes, like, you're writing these notes, you don't want the patient to really know what you're thinking. And so you start just basically doing something like high blood pressure and no detail, right? And you do that almost every single time. You're doing the same kind of like rubber stamp of a patient note. And that could be considered, they possibly consider information blocking, right? So what we're having to do is train our providers that they're going to have to learn how to better communicate. And so you can imagine what kind of challenge that can be when you're dealing with physicians. So if you are caught doing this right now, there's not a lot of teeth in this law, and they're really not enforcing it because, again, practically speaking, you all are doing other things inside these facilities. And so they're not really, the government's not enforcing it right now. The Office of Inspector General, which is like basically the police force for Health and Human Services, is just sort of letting this ride. But if you get caught, eventually, you could be dealing with a penalty of $1 million per violation. It doesn't apply to healthcare providers as of yet. It only provides for those folks who are handling the EHI and EHR. Let's see. Another thing, though, we talked about this in the last presentation, the False Claims Act. You may not get in trouble through the OIG at this point, but you could still get in trouble under the False Claims Act because you're not complying with the law that you were supposed to be complying with. There's tons of exceptions to this, right? If you have an issue and you're doing an update to your system, if you're dealing with somebody who could potentially be like a trafficking victim, you know, there may be exceptions for that. All kinds of exceptions that you should be looking into with inside or outside counsel before you do it. And I'll skip over the breakdown of the exceptions, but this is for you to have. Again, this started April 5th, 2021. It's a big deal. It's a big deal, it should be a big deal for lay people who are not in the healthcare industry, right? Who are just going to the doctor on a regular basis. An example was, I went and had allergy testing done like 6 or 7 years ago, before this was available, and my ENT had not quite gone to electronic records. And so I called the other day to ask for a copy. And of course, I forgot that it was something I could find on the portal. The receptionist asked me to go on the portal. I went on the portal, my allergy results were not there. And so now I'm in this like loop of trying to figure out, how do I get this? She said she would mail it to me, it didn't come. And so what I'm telling you is that, why I'm telling you this story is, we're going through a transition period right now, right? And I think the government is giving us a lot of grace in terms of having open notes. However, there's going to be a stopping point to that. And these little road bumps where people that work in the healthcare industry don't know about the open notes rule could end up, causing a lot of liability for your system or whoever you work for. And so the punchline is, this went into place, this went into effect 3 months ago. It is active, and you should be having discussions internally about the open notes rule. So thank you.
Thank you, Zenobia. Again, everyone, please remember to put your questions in the Q&A function. I caught the couple in the chat, but we could keep them there. And I think we have another door prize before I introduce our last panelist.
Thank you so much, Brittany. We do have one more door prize, and this one will be a 150 Amazon gift card, which I could have signed up for that one. So we have Miss Angela Shu as the winner. Just make sure that you stay till the end and look out for your email. Thank you.
Congrats, Angela. It's a great one. So our last panelist this evening, Fred Guyana, is certainly presenting a hot topic, vaccination policy. So Fred is a member in the Dallas office of Frost Brown Todd. His legal practice focuses on labor and employment issues, and he's a member of the firm's COVID response team. During his career, Fred has managed all types of employment disputes, including claims under Title VII, the Age Discrimination in Employment Act, the Americans with Disability Act, the Family Medical Leave Act, the Fair Labor Standards Act, and numerous state statutes. Fred also handles disputes involving unfair competition issues, including non-competition agreements, non-solicitation agreements, confidentiality agreements, and misappropriation of trade secrets. He has been named a super lawyer and rising star by Texas Monthly. Again, Fred will be speaking with us on vaccination policy. Take it away, Fred.
Thank you, Brittany, for that introduction. I appreciate it so much. And I can tell you from my experience on the firm's COVID response team, this is something that has been a hot topic for many, many lawyers who are in-house and for folks like you who work in the healthcare industry. And it's amazing to me that we've been living with COVID now for over a year. And when you really think about it, you can go to the next slide. It's been more than a year, almost a year and a half. If you remember March of 2020, we all kind of went home, weren't quite sure what we were going to do, but we were all working from home. And when you think about it, COVID had already been within our midst even a few months before that. So it's been a solid year and a half that we've been living with the COVID pandemic. Next slide. And in the beginning, we were looking at things like just simply, social distancing, wearing our masks, making sure we had enough antibacterial soap and things of that nature. But the biggest thing in this area is the mandatory vaccinations and the vaccine becoming available. And my remarks to you this evening will revolve primarily around the vaccine and the policies that relate to the vaccine. Next slide. The best source of information comes from the EEOC guidance on vaccine. And they kind of provide that information in the Q&A format. And the questions that they provided are those that are there in color. the questions that the EOC has attempted to answer for us is, number one, can an employer require the employees to receive one of the new FDA authorized COVID-19 vaccinations? Can an employer ask an employee if he or she has already received vaccine, or similarly require proof that the employee has been vaccinated? Can an employer have its own medical staff or a contracted healthcare provider conduct the vaccinations? And then 4, can an employer fire an employee who refuses to be vaccinated? The answer to all these questions, according to the EOC, is probably yes, with some caveats. And so knowing that, the question is, does the EOC guidance mean that all employers should adopt a mandatory vaccination program? I would say, like they say on ESPN, not so fast, my friend. We actually recommend that, employers, strongly recommend the vaccination, but not necessarily that they require it. But if a company decides that that is what they want to do, it is possible to implement mandatory vaccination programs. And we've seen quite a few of these in the healthcare industry, and we'll get to a case here in a moment that will illustrate that point. If you go to the next slide, I'll give you some of the caveats and go into some more details about what the EOC has said about the various questions that have been raised. The first question, can an employer require that employees receive one of the new FDA authorized COVID-19 vaccinations? Generally, yes, but potential complications. Employers have to be ready to discuss the reasonable accommodations of religious beliefs or disabilities. Vaccinations, they also say that EOC also says that vaccination itself is not a medical exam under the ADA, but if the vaccination program is controlled by the employer, not a third party, questions about the vaccine could constitute a disability-related inquiry regulated by the ADA. So therefore, if you are going to administer the vaccine within your hospitals, you have to protect any information that you gather about these employees and treat it as, HIPAA protected information. So the EEOC is saying that yes, the employers can in fact require that the employees have the COVID-19 vaccinations, but they have to have some reasonable accommodation for religious beliefs and for disabilities or medical conditions that would prevent someone from getting a vaccine. Next slide. Another question that the EOC attempts to answer is, can an employer ask an employee if he or she has already received the vaccine, or similarly require proof that the employee has been vaccinated? Again, the answer is generally yes. You can ask an employee if they've been vaccinated, and the EOC has said that is not a disability-related inquiry. But asking why the employee is not vaccinated may elicit information about a disability, and therein lies the rub. An inquiry can only be made if the question is job-related and consistent with business necessity. Those of you in the healthcare industry, you're probably going to say that it is job-related because you need to be able to interface with patients, and you got to interface with other, medical staff that are providing care to the public. And so in these situations, it's probably going to be medically necessary and necessary for the companies to ask you those questions as to why. And really what you're trying to do is to elicit that information as to whether or not an accommodation is necessary. So I would try to house those questions about the why as to say, is there a particular accommodation that is required? Is there a religious belief, or is there a medical condition that is preventing you from obtaining that vaccination? Next slide. Another inquiry, again, that the EOC has asked about is, can an employer refuse to hire or fire an employee who refuses to be vaccinated? Possibly yes, in limited circumstances and situations. You may have to explore the reasonable accommodations as we've talked about. And you have to ask whether or not that person who's unvaccinated poses a direct threat. And so you have to undergo potentially that discussion about accommodations and about whether or not you can make certain exceptions for that employee. There is a case, for instance, in the Southern District of Texas that involves a firefighter who was refusing to get certain vaccines, and this is prior to the pandemic. But what the fire department did was they made certain accommodations, such as wearing a mask, and making sure that that individual took all types of precautions. The problem was that the employee did not want to be vaccinated and did not want to take those additional precautions such as wearing a mask, and ultimately the company had to fire that employee. So, you know, making accommodations, making sure people wear masks, making sure that they social distance and do things of that nature when they are unvaccinated is appropriate and can be done. Some other considerations that you might want to think about is whether or not, you know, you're going to allow certain people to be grandfathered in. If they're already employees, we're not going to term them if they're not unvaccinated, but we're not going to hire anyone who's unvaccinated. The problem with that is that you're essentially making accommodations for that individual who's grandfathered in, and therefore it may not be an unreasonable accommodation to allow a new hire to also be unvaccinated if you're making certain accommodations and allowing that other person to be non-vaccinated. So the EEOC has laid out all of these things for us, and this is kind of the premise of what we're looking at. This is the guidance. So it seems to be that you can require the vaccine, but again, if you go to the next slide, the precautions that you want to take into consideration are those for medical exemptions, religious exemptions. Those are probably the two most important exemptions when you're dealing with vaccinations that you want to take into consideration. Next slide. And also you want to make sure that you're looking at the possibility of reasonable accommodations under the ADA and of course Title VII, which includes religious discrimination. You want to engage in the interactive process and seeing if there are accommodations that could apply to that individual. And then you have to do the hard decision making of undue hardship and whether or not you absolutely positively need the person to be vaccinated or if it provides an undue hardship. And when you do that assessment, at the end of it, it is possible to say that an accommodation is not possible and we simply just have to let folks go. And I've been part of those conversations, and I can tell you from experience, those are tough calls to make when you realize that you may have to let somebody go who's a valuable team member, but if you're going to require that those individuals in that position be vaccinated, you can do that, and you can do it on a job by job basis. It doesn't necessarily have to be a blanket, all-encompassing mandatory vaccination policy. Let me show you a case that comes out of Houston that illustrates this point. Many of you probably have read about it and heard about it in the news. It's the Bridges versus Houston Methodist Hospital case. Methodist Hospital had a mandatory vaccine policy. There was 117 employees who sued to stop the mandatory vaccine policy. What was interesting to me from a legal perspective were the claims that these individuals were bringing. Number one, they brought a wrongful termination claim. Two, they alleged that the vaccinations, or the mandatory vaccinations, were a violation of the Nuremberg Code. And the Nuremberg Code went back to the time of the Nazis when they were performing examinations and experiments on prisoners and things of that nature. And there was an international law that prohibits people from being human specimens without their consent. And so that was a very interesting claim that these plaintiffs brought. And then finally, they also said that the mandatory vaccinations were a violation of the Code of Federal Regulations that related to having consent to particular vaccinations under federal law. And so this was the premise of what these individuals, these plaintiffs, were bringing in this lawsuit. So knowing what we know by what the EEOC has laid out, you can imagine that the court had felt compelled to rule against the plaintiffs. And if we go to the next slide, I'll show you what the court held and what they ruled. So the court held that the only claim for wrongful termination in Texas is for refusal to commit an illegal act. So essentially, there is no claim for wrongful termination. As many of you know, in Texas, we are an at-will employment state. So the wrongful termination claim that they were trying to bring, even though they were kind of basically saying it was a violation of public policy, really didn't work here. It didn't fit the mold. So the court made short shrift of that throughout that claim. Then the court also, in doing that, made this note kind of in passing to say, well, the EEOC guidance says that you can have a mandatory vaccination policy. And, you know, if someone had raised an issue about disability or religious accommodations, you'd have to address that. That wasn't the claim that these plaintiffs were bringing. They weren't saying that they had a disability or they had a medical condition or that they even had firmly held religious beliefs. They were simply saying they thought the policy, a mandatory policy, was against the law. And so then looking at the Nuremberg and the Code of Federal Regulations, court stated the employees were not human subjects and not coerced into getting the vaccinations. For me, this could all be summed up into one sentence or two sentences there in the opinion near the end of it. It said, Methodist is trying to do their business of saving lives without giving them the COVID-19 virus. It is a choice made to keep staff, patients, and their families safer. Bridges can freely choose to accept or refuse a COVID-19 vaccine. However, if she refuses, she will simply need to work somewhere else. So the court was saying that an individual does have the right to say, I don't want the vaccine. And if they say that, then the company is within their rights to terminate the individual if they have a mandatory vaccine policy. But in this particular case, they had laid it out. They had told the individuals ahead of time. They weren't raising the religious accommodations or the disability accommodations issues. And so the court ruled against them and dismissed the case in total. There's another case that you all should be concerned with, or just make sure you know about. It's a case related to the University of Indiana. The court in Indiana recently ruled that the requirement by the University of Indiana that its students have to be vaccinated to come back to campus for in-person learning, the court upheld that. The court made note that there were, exemptions for people to work, to attend class remotely and things of that nature. And so the court said, yes, the University of Indiana was within its rights to require vaccination for in-person studies and to be back on campus. One other thing, I know a lot of you work for hospitals and for companies. You really need to think about, we talk about the vaccination. We've seen lawsuits related to mandatory vaccination, but there are a slew of other types of claims that come into play when we're dealing with issues related to COVID. For instance, discrimination. We've seen age cases, disability, and gender cases related to issues that have evolved during COVID, particularly when you have layoffs and things of that nature. We've seen retaliation and whistleblower cases related to COVID, failure to accommodate, those type of claims also. The WARN Act is something that people don't always think about, but I can tell you that when COVID first hit in March, April, May, there were a lot of companies and a lot of friends who were in-house who essentially were doing mass layoffs, and they were the concern was, did they have to give people WARN Act notice? And there are some exemptions and exceptions. So it's something that unless you are accustomed to doing mass layoffs, you might not always think about it. So you probably want to seek legal counsel when people raise these type of issues. But I put the laundry list of claims that we've seen during COVID because you really want to think through the employment implications when you're dealing with employees who are complaining about various things that are on this list here. One of the other things that we see right there, wage and hour. A lot of people are working from home, and people are saying that they can't really turn off the clock when they're working from home. They're working extended hours. And then when you have people going back into the office, you also have people that are having to put on additional gear and things of that nature. And so we're seeing some donning and doffing cases that relate to PPE that employees are using. So those are my comments as they relate to COVID and to the mandatory vaccination policies. If you have any questions, I know we're going to be here for a few minutes more, and we're glad to field any questions you may have.
Thank you so much, Fred. Seeing no questions in the chat at this time, or in the question and answer function at this time, I will turn it back over to Zenobia, who will introduce kind of our next panel. But again, if there's any lingering questions, feel free to pop those in. Thank you.
Thank you. Thank you so much for joining us. Our next panel will be live. It will be general counsel from various hospital systems. There will be 3 different general counsel being interviewed by Darren Skiles, who was our one at our first panel. We'll be having appetizers and beverages. And we will be here at 4400 Post Oak Parkway across from the Junior League and the St. Regis Hotel. live and in person, and we hope you all can join us. Thank you. Galia, I'm turning it back over to you.
I just want to say thank you all for joining us today, and thank you to the panelists for giving us your time and information. Like Zenobia said, our next event will be live, so we do look forward to seeing you. And if you have any questions, feel free to reach out to any of the speakers. Y'all have a good rest of your evening.
Thank you.